Commerce and Law. She is advocate and associate company secretary and IP. She is triple gold medalist and university topper in law. She has over 15 years of experience as CS, IP and advocate. She has worked with Ujjivan Financial Services Limited, Agis Infotech, BSC, Hyderabad Stock Exchange, and Broking House at Bangalore with a commodity trading company based at Singapore. She was partner with one of top IPE where she worked on restructuring of companies under IBC. Currently, ma'am is founder and designated partner at P2S Niyam Advisors LLP, who are partners with Elenco LLP, a reputed firm in multidisciplinary consulting firm providing services in transaction advisory, legal due diligence, risk advisory, forensic accounting, cybersecurity, IT risk, digital transformations, legal advisory, etc. Now I request ma'am to start the session on the topic.
Yeah. So, good afternoon, everyone. Thank you, Anjali ji. Thank you, ICSI IIP, for giving the opportunity to take the session on the group insolvency as well as the cross-border insolvency under Insolvency and Bankruptcy Code. So, this is a post-lunch session. I request members to kindly keep the session interactive, and whatever practical experience you have, you can share. Otherwise, any queries also you can keep on during the session, as well as we'll have a session at the end also. So I always start my presentation with the objectives of IBC, because the entire gamut of whatever the be it CIRP liquidation or voluntary liquidation, personal insolvency, pre-pack, group insolvency, cross-border, whatever maybe the restructuring or resolution of a corporate debtor happens, the entire thing is again linked to the objectives of the IBC. So what exactly are the objects of IBC is, first is to consolidate and amend the laws relating to reorganization and insolvency resolution of the corporate persons, partnership firms and individuals in a time-bound manner. So it is time-bound resolution of insolvency, maximization of value of assets, and promoting entrepreneurship, availability of credit, and balancing the interest of all stakeholders. So with this brief background, I would like to go into the today's topic presentation, that is on group insolvency and cross-border. So group insolvency I'll take up, and my colleague Janvi will pitch in for the cross-border insolvency presentation. As of now, as on current date, we do not have any framework in the IBC code for the group insolvency. So group insolvency is a concept where legally, procedurally, a framework should be designed to resolve insolvency in a multiple related corporate entities in a coordinated manner. So the core objective for a group insolvency is to maximize the value for creditors and preserve the economic viability of the entire corporate group rather than the isolated entities. So regarding the legal principle, it is separate legal personality of each company, but it recognizes the economic realities of interlinked group companies. So when multiple entities of a corporate group becomes insolvent, the group insolvency allows their resolution in a consolidated way in one court, that is one adjudicating authority, that is one NCLT. Then the restructuring happens, the group as a whole, and for optimizing the combined assets for the benefit of both group debtors as well as the creditors. So there is a concept of two. One is substantive and the procedural group consolidation. So going forward in our presentation, I'll take you through the concepts in the group insolvency. See, generally, as professionals, we all would have dealt as a chartered accountants, audit, or company secretaries regarding the various group companies, interwoven challenges, complexities, compliances. So, the entire corporate structures group involve a lot of complexities, like complex webs of compliances, and even economic, operational, financial whatever maybe the complexities involved, it may be the parent companies from the subsidiaries or affiliates, or for maybe for the operating across multiple jurisdictions. So when the financial distress strikes, the interconnected nature of these entities creates significant complications for insolvency proceedings. These are the kind of challenges in the interwoven group companies or affiliate or subsidiary companies or parent companies. So, what exactly are the key features of a group insolvency? It is multiple legal entities within the social economic group. So, these concepts we'll just going forward in the presentation, I'll take you through. Then shared management, assets and liabilities. There should be shared management, assets and liabilities in the within the group. And there are, if there is a cross, there are cross guarantees and intra-group transactions, which are so interwoven. If you take them out, it again goes for a operational or financial issues or legal issues, or it may reduce the value of the corporate data independently. The value gets eroded, or the CD gets into a lot of issues which may be not viable for the entire group. So there is an interdependency. And even the unified business operations, there could be unified business operations despite separate legal entities. As we all know, many group companies wherein the operations are so interlinked, if you take it as a separate company, then the entire other group gets affected. So usually, as of now, the current framework is not available. But however, we have seen in one of the landmark case, Videocon, which is given very good precedent and which has set the process for the group insolvency restructuring. So why the group insolvency failed in few cases? Because there were traditional insolvency laws which treated each company as an independent entity, because of which the asset disappreciation has happened because of the uncoordinated liquidations. And there were conflicting decisions taken by different tribunals regarding the different companies, single entity. And because of which the recovery to creditors has reduced drastically across the group. Suppose in some cases, if the creditors are same, the financial creditors are same for the entire group of companies. If individually it went, it has reduced the recovery for the creditors and destruction of going concern value. At group level, if the consolidation happens and goes for a group insolvency, the value can be preserved. And usually what happens when group, if the company goes independently, then there could be a possibility of forum shopping by stakeholders seeking favorable jurisdictions. See, generally, the reality as such, we know the economic reality of group is they often function as a single enterprise only. They share the resources, they cash flows are managed, then business operations, and including the employees. There is a lot of interchangeability between the companies. So, the insolvency laws must evolve to recognize this commercial reality while respecting separate legal principles. So, what are the global perspectives of on group insolvency? Currently, as of now, in India, we have the IBC version 2, which the bill is proposed, which is going to be approved in the next session, after which there is a group insolvency notification, the regulations wherein the central government is empowered to make the respective regulations for the group insolvency. So once those come out, we will be able to go in detail how the group insolvency will be regulated and managed by in the system. So with this perspective, which is still under pending for approval at the parliament level, the bill is yet to be approved. I'll just take you through the global perspectives on group insolvency. We have a unilateral model law wherein the United Nations Commission on International Trade, they have developed a comprehensive framework and model law on cross-border as well as group insolvency. For the group insolvency, we have 2019. And for cross-border insolvency, it is unilateral 1997. So they provide templates for jurisdictions to adopt coordinated approaches, emphasizing like cooperation between different courts across countries jurisdiction. Then again, procedural coordination. This entire comprehensive framework is there in the unilateral for both group insolvency and the cross-border, which is yet to be adopted by India, wherein the entire complexity of issues involved, procedural, joint administration possibilities, all these are very clearly laid down under unilateral. Then we have European Union's recast insolvency regulation, which is in 2015. This again established the concept of COME, that is Center of Main Interest. This is for determining the jurisdictions. It again facilitates recognition of proceedings across member states and again provides mechanism for coordinated group insolvencies, that is including group coordination and cooperation between insolvency practitioner across various jurisdictions, different countries. So then we have US Chapter 15. In US, again, they have implemented unilateral. So US has adopted unilateral model through adoption in Chapter 15, which enables recognition and enforcement of foreign proceedings. This has created a very good framework for cross-border cases, especially for cross-border, and this unilateral Chapter 15 of US is very effective for cross-border cases. Then we have Singapore framework, which is again a leading jurisdiction for unilateral in Asian countries. And they have adopted unilateral model, especially for insolvency courts. The jurisdiction, again, they offer a sophisticated mechanism for recognition of foreign proceedings. Then they have developed an innovative judicial management tools for group restructuring as well as cross borders. As I mentioned, the Indian developments are still at the draft framework level for the proposed group insolvency mechanism, wherein it is proposed for a group coordinator for the entire coordination, then joint application by multiple corporate debtors, then cooperation protocols between the RPs, consolidated resolution plans for the entire group, and how to protect the intra-group transactions from avoidance. This entire framework is again to be notified. This is again in the draft framework mode. So if we claw back to IBC, there are few sections wherein we can link, there are certain clarifications regarding the group. If we see section 62 and 60 subclause 2 and section 60 subclause 3 of the code, where the insolvency proceedings of a debtor company and its guarantor would be dealt by the same adjudicating authority. This is again linking the proceedings in those cases where the debtor and guarantor are part of the same group. See here what they say is the debtor company as well as in case if there is a guarantor, then the adjudicating authority for both these companies will be the same adjudicating authority. Here again, they have linked the corporate debtor and their guarantees forming part of the same group companies. Then we have section 18 subclause F and 36 of the code, which says it gives control of the shares of the subsidiary to the resolution professional and liquidator of the parent company. Here what happens, the control rights of that shares are given even if the company is a solvent company, the control of those subsidiary company shares are given to the parent company, which is in under CARP, to those respective resolution professional or liquidator. So here I have experience. In my case, what has happened, the company had 3 or 4 subsidiary companies, and one of the company subsidiary company, which is 99.99, the corporate debtor was holding 99.99 shares in the subsidiary company, which is doing very well, doing some governance projects. So the resolution applicant has proposed a plan taking control over the shares of the subsidiary by becoming the owner. So this form part of the resolution plan, which is allowed under these sections in case of the parent company taking control over the shares of the subsidiary companies. So what happens in the resolution plan, which is proposed in the parent company? They have to deal how they are going to handle the shares in the subsidiary company. So the SRA will get the control of these securities. Then further, the code again defines who are the related parties in relation to the corporate debtors, including holding company, subsidiary company. These entire gamut of related party, how the shareholding companies, controlling companies, by virtue of some contracts, all these have been clearly defined under the definition of related parties. And section 21 also restricts the rights of the related parties. And section 29 here restricts related parties from becoming the resolution applicants. So when the related parties submit the claim, the RP will not include them as part of COC because they are the related party. FC cannot become the member of COC. So usually what happens in group companies, they may have the claim. The group company would have borrowed or they would have lent. So the related parties come into existence. If they submit the claim, the voting rights are not given to the related parties. Then we have section 828, wherein if the undertaking or the company is trying to get into any contracts or any business or commercials with the group companies, in that case, the approval of committee of creditors is mandatory with 66% approval. So in a few cases where these kind of group company involved, then the adjudicating authority had the powers to enabling coordination of proceedings by based on general corporate laws by piercing the corporate veil. So currently we have only the standalone basis of corporate debtors resolving under IBC. The code does not explicitly provide for consolidation of insolvency proceedings across group companies. But however, due to operational, financial, management interconnections among group companies, if separate proceedings will lead to value destruction and inefficiency, the courts have come based on the doctrines derived from the other jurisdictions. They have consolidated and they have ordered for group insolvency. In currently in India, the courts, that is the adjudicating authorities, NCLTs, have progressively used their procedural, their powers, inherent powers through for procedural coordination and substantive consolidation of their judicial powers to address any challenges in the group insolvency cases. So as we all know, the corporate groups usually consist of typically holding parent companies, subsidiary companies, and associate companies. Like holding or parent companies completely controls, the holding company controls, the parent company controls strategy and financing in the group companies. And subsidiaries also, they are controlled either through SPVs or through the decision making. Then associate companies, they are partially controlled or jointly they are managed along with the associate companies. And as of now, the IBCs, we have the mechanism of the restructuring resolution for the CDA, for the independent corporate entity, separate legal personality. But however, the corporate veil can be lifted by court only in certain cases where there is a fraud or improper conduct, or in case the assets are so intermingled between the entities that will erode completely the value of the entire group. Then if there is a significant financial or operational dependency on the group companies. So when the issue started in the market in the implementation of the IBC, progressively the judiciary started evolving the principles which are suitable and applicable in the respective cases. And also judiciary suggested to IBBI to have separate groups to go through and also come up with some papers based on which the recommendations are put in the public, and then we submit the recommendations. Based on that, the regulations were amended or the code was amended. So if we see regarding the group insolvency, the IBBI has constituted a working group in January 2019 to design a framework for group insolvency. Here, the group has recommended a framework for insolvency resolution and liquidation of companies belonging to a group by way of voluntary adoption by stakeholders. Then again, which is voluntary again. And the other one is a mandatory framework. One is enabling framework, the other one is a mandatory framework. It is again for communication, cooperation, and information sharing among IPs and adjudicating authorities and committee of creditors. This is again mandatory, wherein the framework is very strict when it comes to the coordination, communication, or cooperation among these stakeholders. So the committee has recommended in a phased implementation manner. The first phase was procedural coordination of domestic companies in the group. Then the second phase is cross-border and substantive consolidation. The corporate group again consists of holding, subsidiary, and associate form of the companies or the LLPs. Then one more is other intrinsically linked companies. Those also can be included in the group insolvency by way of a order from adjudicating authority, because the entire gamut of things depends from case to case basis. Each CD is specific. The entire group is again within the group also. There may be some kind of intrinsically linkages between the companies. That is again left to the discretion or the judgment of the adjudicating authority. We have the next one is procedural coordination, which is again proposed to be limited only to the group companies in default. And there are certain rules which are going to be implemented for any perverse behavior between among the groups regarding of their solvency. In case some companies are solvent, but there could be some transactions because of which there is a perverse behavior in that group, so that company can also be brought into the gamut of group insolvency. So as initially we were discussing, the working group has recommended for procedural coordination, that is mandatory. The other one is voluntary. So mandatory is done by a joint application against all companies of group in default. So there could be a joint application by all the creditors against all the companies for a default in the group. So if majority of the companies has similar creditors, then a joint application can be moved. Then, as we discussed in previous slide, it is again mandatory for communication, cooperation, and information sharing across COC, NCLT, as well as the RPs, insolvency professionals. Then voluntary, we have seen it is single insolvency professional will be appointed and single adjudicating authority will be empowered for the entire group. And a group creditors COC is created and group coordination proceedings happen at the option of COC. Then again, the judgment is left to the option is given to the committee of creditors in voluntary coordination of group insolvency. So one more recommendation is adjudicating authority is empowered to subordinate the claims of other companies in group in exceptional situations of fraud, diversion of funds. In case if there are subordinate claims of within the group companies and there are some exceptional cases regarding the claims of the group companies, fraud for diversion of funds, in that case, regarding the claims between the companies, the power is vested with the adjudicating authority. What are the key advantages is for a group insolvency? It is again promotion of information symmetry, reduction in cost of insolvency resolution, maximizing the value of the group, preserving the value of the assets, then reduction in cost of capital for the process, then increasing certainty for stakeholders and saving judicial time. So, as we all know, the judiciary time will be saved by consolidation of group insolvency of the entire group if there is a stress in the entire group. If individually each company goes to different jurisdictions of NCLT, each bench will be burdened. In case the group coordination happens, it saves the judiciary time as well as it reduces the cost incurred for each process. The cost, if you have group consolidation, the cost also will come down. So they have segregated group insolvency has segregated the companies into 4 categories: C, CA, CB, CC, CD. So separate proceedings will be opened for these corporate debtors if uh, joint meetings. Each category there is a specific regulations which may be notified in the next session when the IBC version 2 is going to be the bill is going to be passed. So till now, any questions? Sir, hope I am clear.
Yes, you are clear. Very much audible. Thank you.
Okay, thank you, sir. So we have the working group has come out. What are the disadvantages? The one is the potential for cost to increase if the basic principle of asset partitioning is disregarded without justification. Then cost of monitoring the assets of group may increase the cost of capital. So they have seen in case if the asset entire group asset is scattered all over and the asset partitioning happens, then the monitoring supervision over the cost of the assets is increases the cost of capital. Then in case if professional or experts who are appointed, if they give strategy advisory to group insolvency, as a group, the expenses may be high for the professionals. Then potential for unfair capture of value by some stakeholders. See, in many of the cases we have seen majority of the there are disputes among the committee of creditors themselves for the voting rights, distribution, then again dissenting FCs. So there is a kind of litigation which may happen and the principle of this asset partitioning and what kind of recovery to stakeholders This may increase the dominating lenders to lower the recovery for the other creditors. So as we have been discussing the group insolvency, first time in 2025 amendment, they incorporated a statutory mechanism for group insolvency, which is going to allow affiliated companies within a group, interconnected distressed companies to undergo resolution in a coordinated or consolidated manner. Earlier, there was no legal framework for handling such scenarios, and courts have to only rely on equitable concepts and ad hoc methods. So currently, the consolidation of proceedings was happening where assets and liabilities were intertwined, and the separate processes were not possible in the where separate processes will completely erode the value of entire group. The consolidation of these companies were ordered by tribunals, and first different RPs were appointed, but again after few months of experience, single insolvency professional was appointed for the multiple group entities, because there was a lot of duplication of work, and each RPs were for coordination of information sharing. So with the amendment, it was proposed that creditors have to apply for group insolvency if they can demonstrate interdependence. And this framework is particularly relevant for companies with cross holdings, intercompany guarantees, or shared financing structures and operational dependency. Again, this amendment aims at maximizing the value of the group, prevent conflicting outcomes, and streamline the complex resolution process of the business groups. So with this brief background about the group insolvency, we can go to few case laws which we can discuss. So when it comes to the judicial pronouncements and jurisprudence overview, uh, basically some of the companies which has interdependence among the operations or financing structure, their NCLTs have faced difficulties and the companies have faced difficulties, and whoever the stakeholders, especially the insolvency professionals and the committee of creditors, they were facing a lot of difficulties in execution of the restructuring of the group companies independently. So the Indian judiciary has played a very proactive role in shaping group insolvency jurisprudence by ordering consolidation, coordination by based on the economic realities and the stakeholder interests. Then they have applied the lifting of corporate veil, especially initially in the JP case, Chitra Sriram versus Union of India, where Supreme Court has invoked Article 142 of the Constitution to protect the home buyers by treating them, that is holding and subsidiary company, as one. Here, the court has recognized the operational and financial interdependence based for coordinated insolvency resolution. This is, this is in Videocon case, where there was operational as well as financial interdependence among the group companies. Then for balancing the interest of all the stakeholders while ensuring procedural fairness, various NCLT NCLATs have ruled, and they have affirmed the importance of commercial wisdom of Committee of Creditors regarding the consolidation of group company proceedings under IBC. So when we discuss about the approach for the group insolvency, there are three kinds. One is procedural consolidation, the other one is substantive consolidation and lifting of corporate veil. When it comes to procedural consolidation, assets and liabilities are kept separately, each independent corporate debtors, then separate COCs, but information and processes are coordinated among the group companies. Then single insolvency professional is appointed to streamline the proceedings among all the group companies. And all the group companies, the CRP date will be the same. And public announcement, all these, the commencement date remains the same. This is procedural consolidation. Then when it comes to substantive consolidation, the entire assets and liabilities of all group companies are pooled and a single estate is formed, and single COC operates for the entire group, and intercompany debts are eliminated. So whatever, excuse me, just 1 minute. Give me a minute. Sorry, I was on a call.
Okay.
Then we were discussing about the procedural consolidation in group insolvency, wherein each independent corporate debtor assets and liabilities are kept separately. But however, in substantive consolidation, all group company assets are pooled as a single estate, a single COC operates, intercompany debts are eliminated here, and only they are allowed in extraordinary situations only for practical complexities, in case that too the powers will be vested with the adjudicating authority. And the third concept is lifting corporate veil, where the courts can pierce the corporate veil to treat the group companies as a single entity. Typically, this is done only for the cases of fraud, where there is an unfair conduct affecting the creditors, and dissipation, asset dissipation happens among the group companies. So when the benefits of group insolvency, as we were discussing, it facilitates the value maximization by preserving the integrated business operations of the entire group, and reduces the litigation and administrative costs for a single coordinated proceedings. Then there will be centralized management, which will be taking the decisions. And again, it improves the stakeholder confidence by way of coordinated communications. And again, the creditor negotiation power in the commercial wisdom of COC is strengthened by unified committees, where collective resolutions happen for the group. And it promotes again the resolution of the distressed group, which preserves the jobs and also the business continuity. So the recommendations, what the strengthening the group insolvency, the committee has recommended to define clearly what constitutes the corporate group should be defined very clearly, and to introduce procedural forms and guidelines for the uh, joint insolvency applications covering multiple group companies. And they also the more powers will be vested now with the adjudicating authorities to whether to admit the group insolvency, whether to allow the inclusion of some companies into the group insolvency, or to add some more companies, and what will be the timelines for addition or inclusion. Then appointment of multiple RPs or over any one single RP who will be coordinating or overseeing the group. Then joint creditors committee meetings across the group. Then inter se voting rights adjusted for voting rights. This is going to be very, very critical in case of a group insolvency. So I see as I have handled a large size company in Hyderabad NCLT, wherein the shareholdings, the committee of creditors, voting rights and distribution, there legal issues arise. But however, it is once again as per the IBC code, and even the after the IBC version 2 gets notified, the rules, the regulations will be amended for the purpose of group insolvency. There we can see in case if it is they're going to be bring clarity regarding the group insolvency voting rights of the committee of creditors, so that future litigations can be avoided among the creditors. And again, the committee was recommending for a joint public announcement, consolidated information memorandum, then invitation of EOIs, then permit the resolution applicants for to bid for the entire group with the option to divest unrelated assets, then develop a funding mechanism for any litigation related to avoidance transactions, and also the exploring the mediation or settlement options in the group insolvency is also, maybe we can expect something regarding the mediation in the group insolvency. So we'll discuss the landmark case in group insolvency, that is Videocon case. This is the largest group insolvency case as of now. It is in the Videocon group, we had around 15 companies. CRP petitions were filed in 2018 by SBI in NCLT Mumbai, wherein this group was diversified from consumer electronics to oil and gas, telecom. They were in DTH. They were into a lot of consumer related products in the market. The entire group was rapidly expanded. They have expanded into many unrelated sectors, which has again led to poor returns and also diversification of intercompany funds, diversion of funds. As we all know, the Videocon scam also was discussed, was in the news. So the entire group was completely heavily dependent on bank borrowings, and around 2017 the total their approximate dues were 90,000 crores, and their major lenders were SBI, Bank of Baroda and ICICI. In this case, what the RBI has intervened under 35 section 35A, where banks were directed to initiate insolvency proceedings against the group company. So in 2018 SBI filed the petition for 15 applications for against the Videocon group entities. So based on the issues which were faced by after the CRP of the group companies, there were a lot of issues between the stakeholders for consolidation and information sharing across the entities. So NCLT, based on the consolidation doctrine of substantial consolidation from US, they have ordered, NCLT Mumbai has consolidated totally 13 companies. Although there were applications against 15 companies, only 13 companies were consolidated as into one CIRP, and the CRP estate was formed. This was in 2020, where the NCLT has ordered for substantial consolidation based on there were common directors, there was shared assets among the group companies, and also common creditors, and there were cross guarantees between the companies, and the companies were consolidation. There was consolidation of financials. So this doctrine from US bankruptcy law, based on this, the NCLT has ordered for consolidation, group insolvency. Through this doctrine, the assets were pooled, assets and liabilities of multiple entities where they are hopelessly entangled. The group insolvency can be initiated. So the NCLT has ordered for group insolvency, and there were the NCLT has made a note. The group insolvency is ordered based on two prolonged tests, that is common control, interlinked debts, shared resources, and one principle is the separate CIRPs would destroy the creditor's value. Hence, entire that out of 15, 13 groups were treated as single economic unit, and two companies, KL Limited and Trend Electronics, were excluded and they were treated as independent. So here the process Twinstar Technologies, that is from the Vedanta group, they have submitted a resolution plan which was approved by 95% of the shareholders. Again, there is a haircut here, 95% haircut for the creditors. In 2021, the NCLT has approved the plan, but however, citing procedural issues in the valuation of the assets of the corporate debtor, various group companies, valuation issues, NCLAT has stated the NCLAT has quashed the NCLT resolution plan approval order. But again, Supreme Court has declined the interference and fresh EOA was initiated. So here in the Videocon case, the major three doctrinal impacts we can see. One is the major judicial recognition of group insolvency and substantial consolidation in India, which has happened, the major group which was under stress. Then this has a foundation for restructuring interconnected corporate entities. And again, once again, the commercial wisdom of COC is upheld. The NCLAT and Supreme Court has clearly held that it is the wisdom and authority of the Committee of Creditors to approve, review, and reconsider any decisions which are important for the corporate debtors. So with Videocon Group in IBC, we had legal innovations. One is the substantive consolidation, then appointment of single resolution professional for all entities, which ensured a coordinated approach and which has avoided the conflicts. Then we have group wide plans. Yeah, 1 minute. I'm just not able to see this. Okay, yeah. So group wide plan. We had a single plan which has covered multiple legal entities, which was unprecedented in the Indian jurisprudence. Then we had cross-entity treatment of creditor claims where it was addressed on a group basis rather than entity-to-entity basis. So again, if we see what are the challenges and controversies, the Videocon case has demonstrated both the necessity and challenges of group insolvency in India, while the pragmatic approach has preserved the value because it urgently needed for formal provisions for legal certainty. The Videocon case has given a formal provisions or the procedural aspects for meeting the immediate urgent asset erosion in the group, and it has provided a certainty for future cases, legal certainty for future cases. See, some challenges were faced in the Videocon cases. Many challenges we can say. One is, as already we have been discussing about the voting rights in the group-wide COC. This is a major issue, including the separate entity, individual CD COC also. There are issues regarding the voting rights and distribution. So the same challenges were faced even in Videocon case. And jurisdictional issues were faced for multiple NCLT benches were involved. Differential treatment of similarly situated creditors across entities. So the same, again, there are a lot of issues regarding the similarly situated, like first charge holder, second charge holder, pari passu. So all these challenges and controversies keep coming.
Ma'am, your voice is not coming.
Yes, sir. I'm just taking 2 minutes break.
Okay.
Yeah, sorry. So there were many challenges and controversies and legal issues which have arise during the group insolvency process in Videocon as well as after approval of resolution plan. So these challenges and controversies we have discussed. So we have one more landmark case, that is SR Steel, where priority of creditors in group context. Here, the critical issues regarding the distribution of proceeds in group insolvency scenario was handled, where the case primarily dealt with the creditor priority that is related to the group insolvency, that financial creditors and operational creditors must be separately treated, and that committee of creditors has discretion in approving the distribution process in the resolution plan. So here the court has clearly recognized the maximization of value, which may require again flexibility in distribution process in case in the kind where the group entities are differently based. So it supports group-wide resolution approaches over rigid entity by entity treatment. So if there is a different distribution mechanism which is based on the commercial wisdom of COC, if there is a uh, distribution which is mechanism which is approved by the COC, that is paramount and has to be accepted among the group companies. So we have one more important case, that is JP Infratech case, where Chitra Sriraman case, where the Supreme Court's intervention in JP Infratech, where the home buyers were spread across the different real estate group companies. Here the court has mainly focused and emphasized that resolution process must balance interest of all stakeholders, including the operational creditor. So this was prior to the amendment bringing home buyers into the as a financial creditor. So the Supreme Court has held that group structure cannot be used to avoid the obligations to vulnerable stakeholders like home buyers. So corporate in by this case, the corporate groups were treated as a unique stakeholder, as a single entity piercing the corporate veil, where stakeholder vulnerabilities, there are stakeholder vulnerabilities, and the group is trying to avoid the obligations. So the emerging, where there are complexities and group companies are there, the Indian courts are established various key principles where the group economic reality or the value has to be preserved while treating the legal separate entity for the value maximization in a coordinated group approach. And even the foreign creditors and proceedings are also given recognition and respect through mutual support between two courts. That is in Jet Airways case, we can see in cross border when we discuss. And there is a flexibility in resolution planning, which is again essential for complex groups. Then public policy considerations for the cross border cooperation is also emerged. It is emerging for the judicial precedents in the cross border cooperations. So we have one more case, few more case laws which we will discuss. Recently, in Gajjala Yoganand versus Birendra Kumar Agarwal, this is in NCLT Hyderabad case, Manjira Retail Holdings. The suspended directors have filed an application for consolidation of CIRP for the group insolvency. So when they file the application, the bench will not only evaluate the interdependency between the company's financial, operational, or whatever kind of interlinkages. Along with that, the bench will also review what they will evaluate whether the case to case basis, what are the facts and what is the background of the case and what are the issues faced in that company, in that group. So in this case, if we see, it's a very good order where the bench has went into very detail. They have verified that the corporate data directors have taken a stand of Videocon case. They have given this as a benchmark, but however, the bench has clearly laid down that the parameters for common control and similar criteria which is there in Videocon is only a starting point for evaluating the consolidation of CIRP of related entities. So consolidation should only be pursued if COC of the involved entities by majority they decide by commercial wisdom, by if they foresee a economic benefit from such an action. So his decision to consolidate or not rests only with the COC, who are not only better equipped to make determination, but also they have some vested interest and they have the commercial wisdom. Here again, the commercial wisdom is paramount, is what the bench has led, and the bench has dismissed the group consolidation. And if we go very detail into the order, they have clearly given the background of the CIRP process, what was happening in the process, and how the directors were trying to mislead the insolvency the IRP and also the bench, and were filing multiple litigations. So considering not only the uh, basic or whatever the judiciary has established the principles for consolidation, but also the bench went and evaluated the facts and background of the case. So when we see, there was a notification from MCA on 18th January 2023, which has issued comments from public on changes to be considered in IBC 2016, that is for the intermingling of assets between corporate debtor and guarantor. Here, separation of assets. Currently, the resolution process focuses only on the assets of the CD alone. But even when the assets of the CD and its guarantors are closely interlinked, like CD's machineries on guarantor's land, or in case of inefficiency in separate proceedings, like resolving the CD's insolvency without including guarantor's assets, then proposal for inclusion of guarantors assets, these entire intermingling of assets between CD and guarantors, these are all practically happening in the companies. And there are also linkages between the corporate debtor and its guarantors assets in secured credit. Like majority of the times, common secured creditors, like often banks and secured creditors, have interest in both the corporate debtor and guarantors assets, which again separated will create legal complexities. Like we have in Surface Act, secured creditors can take possession and sell the guarantor's assets. So here the amendment for consideration was to propose the secured creditors may sell such assets through a special window under CIRP. Again, they have to ensure the rights of guarantors under Surface are protected. Then that notification further considered resolving interdependent entities within a corporate group. Like for operational and financial linkages, where companies within a group, usually they have interdependent operations and finances, which again complicates resolution when multiple CRPs are going. Then duplication of efforts, which again CARP duplication increases the cost, and also intercompany linkages are required for a resolution. Then it is better to have a consolidated approach, which will again reap the benefits, improve the synergies, cost efficiency, and value maximization. So as we were discussing, the paper also had judicial precedents for consolidated CIRP. So in majority of the cases, they have consolidated CIRP of related entities for maximizing the value, and they have proposed for the holding subsidiary companies for having a common RP, and adjudicating authority can have the rules, can set the guidelines to improve the coordination and recovery. Then as we were discussing these, whatever comments were put in, that was for cooperation and coordination among COCs. Related companies were can apply to the AA for seeking coordination and cooperation in CIRPs. Then specified, then as per our new amendment, the IBBL will again specify the procedure. So this is yet to be notified. Domestic, a formal domestic group insolvency procedure is again they have considered, and in CBIRC2 report on the cross-border and group insolvency is considered, and the framework is prepared. Once the version 2 2025 bill gets passed, these complete whatever rules or regulations the committee has recommended, that is going to be the framework. So when we were discussing the concepts of group insolvency and how this has evolved and what are the related relevant notifications or the committee reports, and we have touched upon few case laws related to the group. When we have seen, while all through the discussion, we were going through the substantial consolidation and procedural consolidation of group CIRPs. Then again, we have discussed about the lifting of corporate veil for CIRP. When we see, we have few of the cases which were admitted into the group insolvency, like we have SBI versus Videocon. Then we have Sahakari Bank versus AVL and AVFL NCLT Mumbai. Then we have Premia Projects, where the company group consolidation was made between the Premia Projects and Solitaire Infomedia. Then we have AMB Infrabuild Private Limited. Then we have Shrey Infrastructure. This is one of the important cases. Shrey Infrastructure Finance Limited and Shrey Equipment. This is again NCLT Kolkata bench. So we'll discuss few points in Shrey. Procedural group, wherein in some of the cases where procedural consolidation was done, so that no assets and liabilities are independently handled. This is again has happened in Sachet Infrastructure and another company. Then we have Uttam Galva. So this is the list which I have just put in my presentation. So when we are discussing about the benefits of group insolvency, there are many challenges which have come in group insolvency. One, as we have been discussing from beginning, that is the committee of creditors, lenders or financial creditors. So there could be misalignment among lenders who are managing the CIRPs, like cross linkages, corporate guarantees, shared expenses, especially when it comes to sharing the CIRP cost. There could be issues between the committee of creditors. Then each creditor want to maximize the value. They want more during the distribution. Then managing multiple CIRPs is again complex, and again it leads to communication issues. And when it comes to lenders, the main distribution and voting rights issues. And when it comes to the adjudicating authority, it is again jurisdictional fragmentation. That means different courts, the group spread over across various jurisdictions. The group fragmentation happens, and the entire business of group, different jurisdictional courts, the cases will be filed. Then, like parent, subsidiary, or affiliating companies. Then bringing consolidation at one jurisdiction is also a challenge for AA. Then what will be the challenges for resolution applicant? There are multiple plans for separate CIRPs, that it increases the cost, complexities, then lack of control over group entities, which can disrupt the supply chain linkages. And commercial decisions by individual COCs create uncertainties for resolution applicants. So I have presented a small slide on the kind of consolidation. So we'll discuss few, like Edelweiss asset reconstruction versus Sachet infrastructure, wherein the multiple corporate debtors are involved, and it was a township project which involved land from 5 corporate debtors like Sachet Infrastructure, Magad Realtors, Mehak Realtech Private Limited, and Samiksha Estate Private Limited, and Jamwant Estate Private Limited. Here, the RP himself has rightly argued that developing the entire township requires simultaneous insolvency resolution of all corporate debtors as the lands are intertwined in the project. And then the group insolvency was ordered to proceed under the same RP for the 5 companies. In addition to one more company was added. So 5 companies along with 5, one more also added. That was the principal developer for the company. But however, here from the entire group, the NCLT has excluded 4 companies due to lack of evidence for linking for the project. So here, if we see the developer, he was Adel Landmarks Limited. He was a common developer. And here the court has again remanded the certain cases of to the adjudicating authority for reconsideration, directing the production of agreements. So the developer, for adding the developer as the company as into the CIRP, there were issues raised by the developer. So NCLT has asked for production of some more agreements to establish whether the dependency is there from the developer company. But however, the RP has submitted the counters, and based on the RP's submissions, a consolidated plan was prepared for the complete township project, and the company has smoothly resolved, and the interconnected companies were forming part of the group resolution. So this we have discussed. This was a specially petition in Chitra Sriraman case where the home buyers were given the status of financial creditors. Here the home buyers had invested in JIL projects, but also they faced delays in possession and all. And there was a group company which was treated as independently, and it was adversely affecting the home buyers of the subsidiary company. So the court has lifted the corporate veil and treated both the companies as one single entity. So here the company, the JIL and JAL, both were JP Infratech and JP full form. JAL, they both were treated as independent, as a single entity. And here RBI was allowed to initiate insolvency proceedings against the JL, the group company, due to its financial distress. Then we have Lavasa Corporation Limited, that is Varsagon Asset Maintenance Limited, and Daswi Convention Center Limited. Here, NCLT Mumbai has allowed the consolidation of insolvency proceedings of 3 entities. This was an appeal from the creditors. The 2 fully owned subsidiaries, though they were not under CIRP, they agreed to resolve their debts. But however, due to interlinked business operations, the standalone resolution for any of these entities was deemed impossible because their entire business models and operations were so interconnected. It would reduce the value of the company, both all the companies. Hence, for maximizing the resolution, the value of the company, the consolidation was allowed only to maximize the value. Hence, here the NCLT has compared the case similarly to Videocon company, wherein the consolidation has happened because of the common control, shared directors, and similar financial creditors, and assets and liabilities and financial accounts are so interlinked. So we have the case law number 5. So far, any questions? Sir, hope I am clear to all of
Yes, yes, you're audible and clear.
you. Okay. Any questions?
No, thank you.
Okay. So any of the participants have any experience or anything to share, they can share. So we have one more case, that is Sangvi Movers Limited versus Alabama Engineering India Limited and Alabama Engineering LLC, Dubai. Here NCLT Kochi. Albana Engineering LLC is a Dubai company and with a project office in Kerala. The respondent was Bharat Petroleum Corporation and Albana Engineering was a subsidiary and it served as a subcontractor in this case. So the Bharat Petroleum has invited tenders for mechanical works at Kochi refinery and Albana LLC Dubai has won the contract and the work was executed by the Indian private company, Indian Private Limited, which is again a subsidiary. This was an under agreement between the parent and the subsidiary. So what has happened? The NCLT has allowed the lifting of the corporate veil to treat the parent and subsidiary as one entity due to the interlinked operations and the financial distress. So if we see, all the NCLTs are giving what kind of linkages they have. They are not only considering the videocon case principles, they are also considering case to case basis what are the dependencies, like what are the interlinked, how the companies are interlinked and what kind of distress it will create in case the stress is differently handled. So here the principle of corporate veil lifting was applied because of the interconnected ownership and common directors. Here the NCLT has clearly recognized the principal agent relationship between the parent company and its subsidiary and also made it a point to note section 221 and 222 of the Indian Contract Act, which deals the agent's lien and indemnification. These are the basic principles based on which the consolidation and the group insolvency proceedings were initiated. So as we are discussing from each case to case, there are different kind of issues considering the group insolvency, how the companies are getting into the group insolvency and what kind of issues they are facing and how the judiciary is interpreting based on the legal principles and precedents. So if we see the case law 5, Sangvi Movers Limited versus Alabama Engineering and Alabama Engineering LLC Dubai. Here again, the same case. The assets and properties, including claims, were held through Indian subsidiary. And one important point here is the bank guarantees issued by parent company were executed by subsidiary. And assets of private limited company, which was held by the parent company, were treated as one for the purpose of CIRP. And even the promoters went to High Court, but it did not prevent NCLT from proceeding with the group company insolvency process. Then we have case law number 6, that is Giriraj Enterprises versus Region Power Tech, represented by RP Mr. Ebenezer Innabaraj, Honorable NCLAT Chennai. Here, the appellant has challenged the NCLT Chennai's order that dismissed the consolidation. Region Power Tech and Region Infrastructure Services, both the companies were, one minute, just give me a minute. So in this case, the appellant has challenged the consolidation of both the companies. The parent company was involved in wind turbine production, while subsidiary was managing operations and maintenance services of turbines. Here the main facts, if we go, both the companies have interconnected business relationships. And after the consolidation and group insolvency was ordered, a viable resolution plan was received. Here, what was the decision based on which the group consolidation has happened is, here the applicants are operational creditors and IBC following the consolidation. See what has happened in in this case, one of the main issue I wanted to discuss is the consolidation of group company was filed by operational creditor. So again, not the commercial wisdom of the COC. It is, in this case, the operational creditor has filed for consolidation. So considering the facts of interdependency and considering both has to be consolidated as a group and the proceedings would benefit in the interest of all stakeholders, the group insolvency was started. So if we see, in this case, based on the past rulings, like control of assets, common control liabilities, interdependencies, common directors, here NCLAT has highlighted the maximizing the asset value and potential revival. So these two were prima facie factors for consolidation. So here NCLAT has ruled that both the companies have to be treated as a single unit, and it has allowed for consolidation and emphasized that consolidation was based for the maximizing the value. And again, the NCLAT has not given any merits to the financial claims or the eligibility of the certain appellants. So here NCLAT has considered even the operational creditor has the right to apply for consolidation, but again it depends on the adjudicating authority to verify all the facts, and then they have the authority to issue for the consolidation and group insolvency process. So this is also one of the very important, interesting case, that is Shrey. Shrey is also one of the landmark cases in group consolidation. This is by NCLT Kolkata bench. This was filed by the administrator, that is RBI, because the significantly important, they are important financial sector companies, regulated companies, that is Shrey Equipment and Shrey Infrastructure Finance Company. So so here the consolidation of CIRP of Shrey Infrastructure and its wholly owned subsidiary Shrey Equipment was ordered, and the consolidation of committee of creditors has happened, and the consolidated resolution plan was submitted, and the time taken during the application process of 180 days was excluded. And here I would like to bring to your notice that why the consolidation was warranted in this case, because of several factors, like there were common directorship among both the companies and the control, and also the assets were so interlinked, interwoven, and it was total interdependence. The completely both the companies were interdependent on each other and they were inseparable. Both the companies were managed seamlessly and indistinguishably, like it was operating as if both the companies were the same company. hence RBI has appointed a common administrator and common advisory committee like a COC for the Shrey Group company consolidation. And there was entirely no opposition. None of the stakeholders have opposed for the consolidation because it aimed at maximizing the value and save the administrative cost and entire simplification of the compliance and restructuring of the stressed debtors. Then immediate effect, NCLT has ordered for group insolvency, and the administrator was instructed to call for a consolidated resolution plan under the IBC for both the companies. So I had a small presentation on especially on the Shrey equipment. I would like to just point contours of the plan. I'll just read out. So I had a small presentation. So if we go to the background of SCFL, that is Shrey Equipment Finance Limited, they were providing financing solutions to equipment purchaser and also preferred financing and leasing schemes offered in conjunction with OEMs, that is equipment deployment and spare part financing, exchange program financing, and they used to. It was a public limited company and also leading infrastructure financing company and one of the first private NBFCs. And SCFL provided financing solutions to and Shrey. When it comes to Shrey had a scheme. This Shrey has filed under section 230 in connection with the proposed scheme of arrangement with SCFL, with its banks and financial institutions, which has provided them loans and working capitals. So here the scheme which has referred for objective to consolidate entire group companies, that is 2 companies, by way of slump exchange. So this slump exchange was again transfer of undertaking to the transferee on a going concern basis without values being assigned to individual assets. So the entire liabilities were in exchange of issuance and allotment of shares by the transferor to the transferee. So the slump exchange was with the prior approval of the creditors. Then again this application was filed for approval. And the scheme was again contemplating for the formal approval from the creditors as well as the NCLT. Then again, the proposal included conversion of debt not less than 75% as part of the scheme. So here what has happened, the proposal was first for scheme under section 230. Then again, UCO Bank, which was the lead lender here, they went and filed a separate appeals against the order of NCLAT. Then again, the NCLT ordered for status quo in this process. So entire these group things, lot of issues has happened. And finally, there was a plan in the group consolidation. So insolvency started in 2021 and COC was constituted. Then Form G was issued. Then close to, I think, a lot of companies have submitted the plans. But again, the NARCL, that is National Asset Reconstruction Company, has submitted the highest plan with the evaluation matrix high scoring. The plan was approved by COC, and this again the restructuring was through a upfront cash. Then again, whatever the cash generated, cash equivalents in the corporate data distributions, then how the loans receivables have to be treated, how it has to be transferred to ARC for the total consideration. Then how the ARC trust will hold the issued ASRs. Then again, what is the total sale consideration cash component and what is the investment? The NARCL has proposed some investments which was again payable through a quarterly payment by way of an underlying asset. So it's all through a non-committed instruments in the form of OCDs it was done. And equity also was held, 20% of the equity was held by assenting financial creditors. So this is how the entire group got restructured. I had few contours of the plan which I wanted to take you through. So this is also a good consolidation of a larger conglomerate and a very good plan is getting implemented in these companies, in this group consolidation. So we'll have one more case law. That is, I think I'm taking a lot of case laws. Hope that's fine.
Rather, it is more helpful, ma'am. We appreciate. At
Thank you.
least case laws basically should be there. So it is good for us. Please continue with that.
Okay, thank you, sir. So this is the last case law anyhow. We have Pani Logis versus Sona Alloys Private Limited. So the CIRP was admitted against one of the companies, Sona Alloys. Then again, respondent now to Ganga Advisory. Separate CRPs were initiated, but the dates, if we can see, the CIRP was admitted in Ganga Advisory on 2019. Then again, another company, it was admitted in 2020. And one more company in the group, Neuromet, it was admitted in 2019. So there were 3 separate orders for admission of 3 different companies. But however, the one of the creditor, they have filed for group consolidation. But based on separate cause of action, separate defaults and different amounts to different creditors, and even these separate entities were so different that consolidation was impossible. Hence, even the application was filed, the NCLT, after verifying the practical challenges, they have given an order saying that the consolidation of the proceedings of these companies are impossible. So I think it is always better if we want to understand. I was trying to touch upon the only the highlights of the cases. If you go very detailedly and read these orders, we will try to understand even much better on the concept of group insolvency, like Shrey, Videocon, and all these cases which I have given in the slide. If we go and read, it will be very beneficial and we'll understand the entire concept of how the group insolvency are being admitted. And most probably once these notifies, we will get the regulations for the group insolvency process as well. So any questions so far? I am almost done with my group insolvency presentation. Before we go to move to cross border, any questions, sir, or any views, or anyone want to share any of their experiences?
In group, I mean group insolvency, when like company A and company
Hmm.
they have different kind of financial creditors with different proportion. So how their claims and voting rights are consolidated?
Um, Sir, see how the claims and you mean to say how the claims are consolidated and how the claims, how the voting rights are assigned.
Yes.
So what happens when the group insolvency is ordered? When the group insolvency is ordered, the entire proceedings of the interlinked companies, the process starts, then there should be few contours which has to be complied, like as we said, common creditors. So when they submit the claim, it is again the claim verification and claim admission process is same as such. The how independently we handle. Hello.
Okay.
So
Okay.
it again the creditor submit the claim, sir. How in group how it happens? Each creditor will submit their claim. Suppose if the say SBI has a claim, SBI has claim in company ABC and ABC are now under group insolvency. So they will again submit the claim as a whole in the group insolvency for these three companies. So based
So
on
one is
common
that
claim,
financial creditors have to be same, but what about operational creditors?
sir, operational creditors again the list will keep on adding, sir. The group they will keep on adding. Maybe, sir, I think it is good if we can see from the IBBI site, like Videocon group company claims. It is all public document. So
Madam, I can add my experience if you want.
yes, sir.
I've
Yes,
handled one of my group insolvency
yes,
matters.
yes, sir. Please.
So, for all the unique claims in each corporate debtor, that claim has to be considered uniquely. And for common claims, like if there are two corporate debtors and one has given a corporate guarantee for the another, so the principal corporate debtor's claim is considered as the unique claim. And likewise, all the claims are consolidated, and on those basis of claims, so basically, in consolidated CIRP, the CIRP itself is considered to be of a single entity. We have to assume that it is
Right.
a single entity, both the entities combined together. Then the unique claims are to be added, and therefore a COC is constituted. With respect to other claimants, so if an operational creditor is having different claims in three different entities, these three different claims have to be added together. If there are duplicate claims, then one claim of the main company with which the main transaction had occurred, that claim has to be considered.
Yes. But they'll add all the claims together and they'll
Unique
submit them.
claims have to be added and duplicate
Yes.
have to be
Yes.
avoided.
Right, right. Duplication they will avoid, but they'll add the amount and they'll submit. Yes.
Right.
Right, sir.
Okay. Okay.
But once this IBC version 2 the bill gets passed, the entire form submission of claim will get entire rules or regulations in this regard. That it will be very clear.
Mhm.
So, for
Fine.
example, you can, if you want to see, I have given the list of cases where the group insolvency happened. Now on IBBI site, we can see, sir, how the claims have been submitted.
Fine.
Okay. Any more questions?
Madam,
Thank.
just one that we are expecting that there, in addition to group insolvency, there should be provisions for group liquidation as well. What if the group insolvency fails? There are
Hmm.
no provisions of group liquidation, and then the entire exercise it fails. So let's see.
Yes, sir. You are right. Then we have emails and also suggestions to the IBBI, wherein we can submit all this whenever the papers are being discussed. So I am also part of one of the IBBI and IPA committees. So definitely we'll put forth this point, sir. Good one. Thank
Thank
you.
you. Thank you.
So we'll go to the cross border. My colleague will start the presentation.
Reach.
Please share. Give us a minute, sir. We are sharing the PPT. Is it on desktop? Is the PPT visible?
Yes, but you have to increase this somewhat size if you can. Otherwise, it's okay.
Yeah.
Make it full screen.
It's full screen only, sir. It's
Okay.
not visible.
It's visible. Okay.
Just
ये साइड में जो आ रहा है हाँ ठीक ठीक.
is it full screen now?
Okay.
It's not full screen.
I don't know, not on my laptop, maybe at your laptop. I don't know.
No, it's full screen. It's full screen. It's visible.
Okay, okay, sir. So, my name is Janvi, and I'm the colleague of Suhasini ma'am. So I am dealing with the cross-border insolvency in India and the new IBC amendment which has been come recently on 12th August by the Indian Finance. Sorry, sir. Hello. No,
Please
no,
continue,
yeah.
madam. Please continue.
You continue. Okay. So this new amendment bill, it came recently in
पीजी
August.
वाले केसेस में टीडीएस काट के हमारा एडवांस फॉर रिइंबर्समेंट आ गया है.
On August 12, 2025.
फीस
So
का
the new amendment bill
मतलब
has.
मैं बताया ना 2 लाख का हमने भेजा तो 1-1 लाख के 2 बिल भेजे थे दोनों में
This is
एडवांस
related
फॉर रिइंबर्समेंट के लिए तो
for
उसमें
the.
तुरंत टीडीएस काट के 99,000 दोनों में दे दिया है.
Requesting all participants to please mute.
खर्चे वो रेज किया है उसका तो भगवान ही मालिक है.
वो कितने कितने का रेज कर रखा है आपने?
वो भी हमने 1-1 लाख का रेज किया हुआ है.
वो तो नहीं होता.
हाँ
वो तो नहीं होता.
हाँ
Ma'am, please continue. I have muted.
Okay. So this bill has been introduced on August 12, 2025 by the Union Minister Nirmala Sitharaman for the cross-border insolvency, which was not there earlier. So earlier, there were only two sections in the IBC, that was section 234 and 235, which was dealing with the cross-border insolvency, but it has never come into the picture. So 234 is dealing with the bilateral agreement, in which it talks that the central government to enter into the bilateral agreement with the foreign state for enforcing Indian insolvency law internationally and vice versa. However, this provision remained largely theoretical because we have never entered into a single bilateral agreement till now. So, what was the main problem which was happening was that this section is only aspirational. It is never came into an operational basis, and the second was that it is dependent on the reciprocal arrangement that has never been materialized. And the third one is no substantive treaties rendered this provision into effective. And second is section 235, which is the letter of request. So this permitted the Indian adjudicating authorities to cooperate with
foreign courts by assisting in evidence gathering and related actions within the India for foreign insolvency cases. But the cooperation remained contingent on goodwill and reciprocity of foreign courts with no binding framework. So there was only the problem with this section was that only limited voluntary cooperation. If it was voluntary cooperation, if no one is cooperating, nothing can be done. Second one is that no mechanism for coordination was given under this section, that how we have to proceed for the cross-border insolvency. And third one is it lacked a specific provision for conflict resolution. So the critical gap was that no substantive framework was provided for recognizing of the foreign proceeding and enforcing how to enforce if some foreign order was given in the cross-border insolvency, how to enforce that, how to coordinate with the parallel insolvency proceeding across the jurisdiction outside of the India. So and plus there is a there is a unilateral model law which is followed by foreign countries that has for which the India hasn't participated. So that's the reason we are lacking behind in the cross-border insolvency. Uh, so these are the two cases which is showing that how this inadequate framework has become, how inadequate IBC was there in related to the cross-border insolvency. So the first case is State Bank of India versus Bhushan Steel. In this, the NCLT initially ordered that the company is the US, whatever the US based assets of will be seized in the that order was given by the NCLT. However, the order could not be sustained owing to lack of coordination with the US government. So this is the lack which we have faced. The second one is related to the Go Airlines insolvency, in which the similar issue was faced by the NCLT, and the NCLT is burdened to sketch the first of its kind litmus test to administer insolvency against the airline whose issues would require a pan-jurisdictional outlook and cooperation. So in both of the cases, like for the cross-border insolvency, no coordination was provided to the NCLT, and we did not have any like how to proceed for that insolvency. So due to these lack of activities, the IBC is became an inadequate for the cross-border insolvency. And since there was no unilateral model law and a uniform framework for proceeding of the cross-border insolvency, we cannot handle the complex cases which were going outside the jurisdiction of the India. So next, I'm dealing with the landmark case, which is the Jet Airways insolvency. This is the only case which we have faced for the cross-border insolvency mainly. In this, the Jet Airways, which is founded by 1991 by Naresh Goyal, and it began its operation in 1993 under the Open Skies policy. The airline became the first premier international airline with over 450 global destinations, and it was known for its premium service and a strong global partnership. It reached its peak in 2007 and till 2016 as India's second largest airline, but the downfall started in 2007 itself when it acquired the Air Sahara. So they were Air Sahara was facing the issue from 2006 itself. They were already in the debt, and the Jet Airways, they thought that if they will acquire the Air Sahara, they will become the second most airline in the all over country, and plus outside the India as well, because they will be participating in global as well as in international and national airlines. So that's how they have acquired it. But after acquiring it, they got to know that there was so much debt pending in the Air Sahara that they were not able to fulfill that. So that increased the debt and the financial burden on the company itself. Plus the rising price of the fuels of the airlines. All the employees of the Jet Airways, they were asking for the highest salaries, and intense competition from the low cost carrier like Indigo, that also started happening. And due to some internal mismanagement and employees unrest, weekend operations, they became the reason for the downfall of the Jet Airways. In 2019, when the Jet Airways got burdened with rupees 36,500 crore of the debt, and they have suspended its operation. They have laid off all the employees, all the pilots. They have left the job. After that, due to since there was so much debt, the creditors have initiated the insolvency proceeding in 2019, and they filed for the CIRP before the NCLT Mumbai. Simultaneously, in Europe also, the insolvency is filed by the European creditor in Netherlands, and this was the first parallel insolvency proceeding in both jurisdiction, in Netherlands and in India, which raised the jurisdictional question on handling how the multinational corporate insolvency will be going on. So what the NCLT Mumbai found in Jet case, that the main assets and the office of the Jet airline was in India, and as per section 234 and 235 of the IBC, they could not apply no reciprocal agreement with the Netherlands. So NCLT declared the Dutch proceeding null and void, claiming exclusive jurisdiction in India itself. And afterwards, the NCLAT in 2020 directed coordination between the Indian RP and Dutch trustee. This resulted in the proposed cooperation model approved in 2020. So this proposed cooperation model, it came into picture in Jet Airways only, and they allowed this joint management of the asset by Indian RP plus Dutch trustee, and the COC representation and mutual communication also happened. So this marked as the first practical cross-border insolvency cooperation in India. After uh, so the RP, as per the CIRP procedure, they have started calling for resolution plan, and there were many plan came, but they failed in everything. Only the Jalan Karl Rock Consortium, which proposed rupees 1,375 crore resolution plan, that has been approved by the members of COC, and rupees 475 crore was given to creditors for and rest for the revival and operational creditors also. So this plan was approved by the NCLT in June 2021, but they faced execution issues after later. The SBI, they have challenged this resolution plan for because of the non-compliances in the Supreme Court. So the things they have mentioned is that there is a non-payment of rupees 350 crore in the time, and they ignored the employees' dues, which is of rupees 715 crore, and there was no clarification on restoration of the flying slots. So these were the reason they have given, and they told that since this plan is non-compliant, we cannot proceed further with this. And since the Supreme Court heard it, and they quashed this resolution plan, and it showed that this is the contempt and delay and the bad faith, and Supreme Court ordered liquidation under section 33 clause 3 of the IBC. So what was the main issues which we face in the cross-border insolvency and bankruptcy court? So since international framework, they were using the unilateral model law, which India is not using till now. So we have the limited statutory framework, because only section 234 and 235 is dealing with this. which permit bilateral agreements and letter of request to foreign authorities. However, these provisions do not specify the exact procedural mechanism, like how we have to handle such cases which is going outside the jurisdiction of the India. So we have left with incomplete and impractical multi-jurisdictional scenarios, that how we are going to deal with that cases. Second is dependence on bilateral treaties. Since Indian framework requires separate treaties with each country. So assume if a company is having lot of multinational assets across the countries, like each country is having one assets. So how we are going to deal with that? How we are going to deal with separate countries? That has not mentioned in our law. So this is again became a problem for us. And plus there is a multiple treaties, legal overlap will be, every country will have their own legal issues, how they are dealing with the insolvency cases. So that also is coming into picture. And significant, since the different countries are having different insolvency procedure in their countries, so that is also creating a delay in the insolvency matter. Next is the absence of reciprocal arrangement. So till date, we don't have any reciprocal insolvency treaties existing under Section 234. There is also no clarity on recognition or enforcement of foreign insolvency order. So that is creating a legal uncertainty for us and the procedural delay, as I mentioned earlier. And next one is the inequality of treatment for foreign creditors. So the IBC lacks detailed provision ensuring equal participation and protection for foreign creditors. So, which many of the may be excluded. Like if we are, since in India we are admitting all the claims, and we have financial creditor, operational creditor. So we are not aware that how they are, in which category they are going to come. So, and because of that, they may be excluded from the meeting and all the procedural requirement which we are doing. So that is also the apps. It is creating an highlight of the absence of including creditor protection norms, because some countries are, every country is having their methodology for insolvency procedure. So we are not aware how we are going to deal with that. And the last one is the non-adoption of the unilateral model law. Since mainly all the foreign countries, since they don't have any cross-border insolvency law, they are following the unilateral model law, which India is not adopting. So we are not aware that how this structure framework for recognition, cooperation, and coordination is going to happen for the cases which is going all over the universe. Next one is the jurisdictional approach to cross-border insolvency in India. In this first case is about SBI versus SCL manufacturing, which deal with possible issues of dominance of domestic creditors in CIRP over the foreign creditors. So the NCLT was unable to address this issue promptly in this case. And the court, when absorbing the possibility of the foreign creditors being the left out or unheard, use this principle of nemo debt esse judex in proporia causes to ensure equal treatment to foreign creditor with those of domestic creditors in India. However, we don't have any guidelines for how we are going to handle the foreign claims, and how we are going, like, what is the percentage of the foreign creditors. So this created an issue for us, and this caused us the unreasonable delays and confusions, which became unavoidable. Further, in the Kingfisher airline case, which is also a good example for this, for showing how inadequate the IBC is, since it does not provide any guideline for the foreign creditor to recover their money in India. There is no proper system provided by the Indian laws where several foreign claims could be included in the single or unified insolvency process. Even though the courts tried to use this principle, but uh, they were not able to use it because there is no evidence that the foreign creditors were aware of the cases which are going into India, and they are not aware what position they are going to get in India as per the laws in India. Since we don't follow any cross-border insolvency procedure or any unilateral model for this, so they are not aware of the position and what position they are going to be held in India. So this is why we are dire need to follow the unilateral model law, so that we can challenge these treaties complexities and reciprocity gaps and the creditor inequalities which is happening. So unilateral model law will cover up all these challenges and problems which we are facing in India. Uh, so and this is the reason we required unilateral model law. So the unilateral model law will be helpful because in that there is a specific rule how we are going to manage the cross insolvency matters without any proper structure for dealing with the issues. Since 1997, the unilateral model law on cross-border insolvency cases was passed by the UN to deal with such issues, and the adoption of this law will be advantage to us because it has a potential to make India an attractive destination for foreign creditors and investors as well. Uh, one benefit one benefit would be the faster information exchange about the insolvency proceeding between the India and the foreign authorities, as unilateral model law provides clear guidelines on the quick communication. Second is the clear guidelines will be provided to the creditors that how they are going to recover the money faster, and it will prevent the corporate debtor asset from being hidden or lost, thereby making the resolution more successful. So unilateral model law is a much more structured and flexible framework in the IBC, and like India should consider adopting this law for the cross-border insolvency matter. So recently, as per the bill, we have some amendment which is going to come. If the bill gets notified, some amendment will be done in the IBC, which will give the recognition to the foreign proceeding. In that, the Indian Adjudicating Authority will now have a statutory powers to recognize the foreign insolvency proceeding, which will facilitate the coordinated debt resolution and enforcement of the foreign judgment while preserving the legitimate local interest through carefully crafted exceptions. So, recognition of the foreign proceeding will be given and the foreign judgment will be enforced in India. Second will be the enforcement of the foreign order. The bill establishes the mechanism for enforcing foreign insolvency. The related order concerning the asset located in India, which will be the safeguard that protect the Indian creditor as well as it will preserve the public policy consideration, creating a balanced approach to the cross-border cooperation. Second, next one is the group insolvency provision. Since this bill has also included the group insolvency procedure provision in the IBC, which will recognize the modern multinational corporation structure, and it will tell us how the coordination resolution mechanism for corporate groups which are having multiple jurisdiction, and they will acknowledge its operation and economic interdependencies that requires holistic rather than fragmented insolvency approaches. Next one is the rule making power. After this amendment, the central government will have the rule making power, which will explain in detail that what will be the rules for the cross border insolvency implementation. establishment of specialized bench which is going to have knowledge about the cross border and how they are going to infrastructure it and develop their expertise in handling the complex international insolvency cases, which will be the efficient and sophisticated matter. Next one is the jurisdictional coordination. So the framework will also now provide how the conflicting parallel proceeding across the multiple jurisdiction will be deal with it, and the all the coordination which will be in with the coordination will be into the transparent manner, so that the primary venue for the insolvency proceeding will be decided, which will reduce the litigation costs will be minimized, and the resolution timeline will also be reduced. The procedure will not be delayed. So these are the 5 amendments which will come into pictures if the bill gets notified related to the cross-border insolvency. So what are the opportunities and challenges which we are going to face? So the opportunities will be that alignment with the unilateral model law. If we are going to implement the cross-border insolvency, the uh, we are going to align with the unilateral model law for recognition, cooperation, and coordination across the jurisdiction. Second will be the enhanced credit recovery, since we are not aware what are the assets which are overseas. So we will be able to identify the assets which are overseas, and so that will be helping the creditors also for they will be getting more recovery for that. And next one is to boost India global standing. If we are going to do the business outside of the India also, invest more foreign investment is going to come into picture, and it will since insolvency will be in the insolvency, cross border insolvency will be there, the foreign investors will also come, and they will invest in India because we will have an insolvency regime for them. Next one is the facilitation of group insolvency. Due multinational complex cases are there. So this joint cross-border insolvency cases is going to be more faster and more coordinated resolution. Next one is integration into the global insolvency ecosystem. So which will after if we adopt this bill, it will show that India is also growing and participating with the international insolvency. It will show a cooperation and promotes an investor friendly environment for us. The challenges which we are going to face is jurisdictional overlap. So multiple forums will have their different authority, which will lead into conflict and inconsistent order across the country. So this is the main problem which we are going to face. The second one is the enforcement of the limitation, since absence of the reciprocal arrangement is there, and non-adoption of the unilateral model law will since we haven't adopted it, so all the jurisdiction may hinder cross-border enforceability. Next one is the legal divergence. Since there are various insolvency laws across the countries, uh, accordingly there are different creditors, right? There are different ranking across the jurisdiction. It is going to be complicated for us to get the cross-border coordination with everything. Next one is the operational gaps. So lack of clear mechanism for the assets identification and protection. So if we are going over the cross-border, won't be able to know like what are the assets which are there in the different countries until and unless the corporate debtor himself tell us. So that is going to be a lack for us, and if we are not able to identify the assets over all the countries, there will be inadequate procedural also. Next one is the capacity and infrastructure challenges. So we also have to train the adjudicating authorities, like they have to deal with all the cross-border insolvency cases if identified, and stakeholders need all the stakeholder, how they are going to come together, and the creation of the detailed procedural rule to deal with the cross-border insolvency cases need to be identified. The last one is the risk of abuse is there. So this framework will ensure that the balance between creditor protection and debtors right will be there, so that the forum shopping cannot happen. So if the forum shopping will be happening, it will be this will be the misuse of the insolvency process. So that is the risk which also will be happening. So there are I have dealt with mainly three international perspective, which is used by United States, UK, and Singapore. So they are following the cross-border insolvency by the unilateral model law. Uh, so in US, like Chapter 15 of the US Bankruptcy Code provides a sophisticated framework for the recognizing foreign proceeding and coordinating with foreign courts, how they are going to deliver the positive outcome towards the creditor recoveries and the swift resolution. They have dealt with all these things in their Chapter 15 of their bankruptcy code. Next one is UK. So UK has implemented the unilateral model law as per their insolvency regulation. In that they have dealt with tailored modification, creating one of the world most efficient and respected insolvency jurisdiction for multinational corporation. And Singapore, next is the Singapore, and the Singapore has become a hub for Asia's leading insolvency, and they have also adopted the unilateral model law, specializing in insolvency judges, and they have also dealt with the legal infrastructure. And they have attract like all the cross-border insolvency. If they have the assets in the Singapore, the countries want to go to Singapore, and because they have such a specialization in that, they will get the more profit in Singapore. So they prefer Singapore as their country to choose the cross-border insolvency case. So this is why, like, this is we should also get inspired from these countries, and we should adopt the unilateral model law. So what is the robust what is the road ahead? So as per the amendment bill, we have a watershed movement in Indian insolvency jurisprudence, which is a bold legislative leap for fragmented, inadequate provision to a comprehensive cross-border insolvency. So we have to be aligned with the international best practices. This reform holds transformative potentials, enhanced creditor recoveries, improve judicial cooperation, protection of the stakeholder interest across the border, and positioning India as a global insolvency ecosystem. However, legislative enactment is only the beginning of a complex implementation journey. The complete realization of these reforms demand sustained commitment across multiple dimensions, building judicial and institutional capacity through specialized training program, finalizing the detailed procedural rule, and for forging international cooperative relationships and bilateral agreements, addressing these jurisdictional ambiguities through clear guidelines and precedent setting decisions, cultivating expertise among the insolvency professionals to navigate how multinational corporate insolvencies are going to be dealt. And as India assumes an increasingly prominent role in the global economic order now, so this evaluation will be equitable and efficient for cross-border insolvency framework, because we will get most of the investors' confidence, economic growth, foreign direct investment will be coming into picture, and the rule of law related to the corporate restructuring will be dependent on the sustainability of the successful implementation. So these are the provision. That's all.
So this is a framework which is already in existence, and one of the cases you have already discussed, and with the IBC version 2, so we are going to get the note after the notified bill is notified, the approved at the parliamentary session. Then we will be having a comprehensive framework for both the insolvency, group insolvency, as well as the cross border. Thank you, Janvi, for the cross border presentation. So, any questions, sir? So far, we had questions on the group insolvency. Let me just check the chat box. Please check any questions. So, I don't see any questions. So, thank you, Anjali ma'am. We have completed our presentation. Anjali ma'am, anyone from team ICSI IIP? Anyone from team ICSI IIP is there? I've completed my presentation. Am I audible?
Yes, yes.
Okay,
Yes, you are audible. I think ICCI has left us to on our own.
I'm calling, sir. I'm calling Anjali ma'am. Yeah. Hope the session was insightful, sir.
Yes, it was insightful, ma'am.
Thank you.
Got something new to learn today.
So thank you everyone for your patience hearing, and also for bringing out the new perspectives and clarifying on the practical issue, Kshitij sir. And thank you everyone.
Thank you, madam.
Thank you, ma'am.
Thank you. Thank you, ma'am. So I'm just waiting for ICSI IIP to.
Yes, ma'am. Yes,
Oh,
ma'am.
okay,
On
okay.
behalf of ICSI IMP, I thank you for taking out time to share your knowledge and experience with us. And I'm sure it was very all participants have also uh, felt that it was an insightful and thought-provoking session. Thank you, ma'am.
Thank you, ICSI IIP. Thank you, ma'am. Thank you, everyone.
Thank you.